So we are going to discuss about beneficial construction. So earlier we completed the strict construction, and here you will see that the approach is little different. Now, how do we know the approach is different, and how should we know that which approach is to be, applied by the judges? Well, we all already discussed that we take strict interpretation in cases of taxing statute with respect to the charging provisions, and we take strict interpretation when it comes to penal statutes. As opposed to that, we have another way of interpreting, and that is known as beneficial or liberal construction. So in this type of construction, so those legislations which are beneficial in nature, which have welfare as one of their objectives, okay, in those legislations, the approach which is taken is the one that benefits the subjects. Okay, that is what beneficial construction is. It's liberal because judges are liberal in taking the meaning which is beneficial for the subjects. So that's the construction that we are dealing with. So usually you find it in welfare legislations or remedial legislations. So legislature intends to provide some benefit, okay, or some remedy, or some do some welfare. In such case, the interpretation that gives effect to that is the one which is preferred to the one that does not give effect to that, and the one that gives more benefit is preferred to the one that gives less benefit. So that kind of construction is known as beneficial or liberal construction. This could be understood in the light of this rule number 46 of Oxford Union Society. It says any member introducing a dog into society's premises shall be liable to fine of $1, whatever the amount, okay. And then it says any animal leading a blind person shall be deemed to be a cat. Now see that what does it say? So if we were to go strictly by the literal interpretation, then an animal, okay, and quite likely it's a dog, as you know, that can help a blind person. So if a blind person has a guide dog, okay, then would that come within the purview of the rule that we just discussed, that a member introducing dog into the society's premises shall be liable to fine of $1. In such case, looking at the beneficial purpose, okay, for which the dog has been brought there, keeping that in mind, a beneficial interpretation is given. So this is not the best example, but it explains that why judges are to go with the beneficial or liberal construction. So in Budhan versus Nabi Baksh, it was said that the object of every legislation is to advance public welfare. Justice and reason constituted the great general legislative intent in every piece of legislation. But it's more clear where the the preamble to the or the long title to the legislation in itself, as one of its purposes, mentions that it's a welfare or beneficial legislation. In such case, so especially in case of labor laws, etc., it becomes very clear that they are intended to provide benefit, or any other welfare legislations, they are intended to provide benefit to the people, and in such case the interpretation has to be done broadly or liberally. So in such case, the court ought to be more concerned with the color, the content, and the context of the statute rather than with its literal import. So this is a situation where it's justifiable for the judges to deviate from the strict literal meaning and look at the color content purpose. So that's what beneficial interpretation or beneficial construction is all about. And quite often judges do so keeping in mind, for example, in India, they do so keeping in mind the various directive principles of state policy. So legislative welfare legislations are quite often brought about to give effect to what the directive principles of state's policy may require. So in such case, the interpretation that gives effect to those directive principles are the ones which are preferred. Okay, so that's the kind of interpretation is known as beneficial or liberal construction. So when the objectives of the statute are not met by excluding certain cases, then the word in such case, then the word may be interpreted extensively so as to include those cases. So if you go by literal meaning, strict literal meaning, well, it fails to give effect to the objective of the statute. Okay, so if literal meaning is adhered to, it excludes. But if a wider meaning is adhered to, then it comes within the purview of the objectives of the statute. In that sense, the word may be interpreted not in the strict, restricted sense, but in the liberal sense. Okay, so that is interpreted extensively so as to include those cases which are included, okay, which we know must have been intended by the legislature, as we can collect from the objective of the statute. So idea is that when the word is ambiguous, okay, when the word is ambiguous and if it is subject to multiple meanings, which meaning should we adopt? The one that gives effect to the object. Okay, that's the one which is to be adopted. But at the same time, you must remember that it's only when the words allow, okay, when the words allow. But if it is clear that some benefit has not been given, then the judges will not extend it to that extent so as to include. Where it is allowed, where it comes within the objective, in such situation, the judges apply this rule. So, when a statute is meant for the benefit of a particular class, okay, if a word in the statute is capable of two meanings, one which would preserve the benefits and one which would not, okay, then the meaning that preserves the benefit must be adopted. As I was telling you, the word allows for two meanings, one that preserves the benefit and the other that does not. In such situation, because it's a beneficial legislation, the one that preserves the benefit is the one that is to be adopted. And that's the true intention of the legislature. So, as I told you, these are applied in cases of remedial statutes, also known as welfare, beneficent, or social justice oriented legislations. So you find it, for example, in cases of labor laws, okay, can be clearly considered as social justice or beneficent statutes. So it says that when the language used in the legislature fails to achieve the objective of the statute, an extended meaning could then be given to it to achieve the objective. But it has to be allowed by the language, okay? If not the plain language, then the extended, okay, meaning of that language should be used in order to achieve the objective for which the legislation has been created. However, at the same time, as I told you, the construction of a statute must not so strain the words as to include cases that have been plainly omitted from the natural meaning of the language. So yes, it is allowed, but it has to be within the objective of the statute, and the meaning, definitely extended meaning is is to be preferred when it comes within the purview of the objective. So it should not be stressed so much as to go beyond the objective for which the statute has been created. So one example might make it clear. So the name of the case goes by Union of India versus Prabhakaran Vijay Kumar, 2008. Okay, so what had happened in this particular case was that this particular approach, that is liberal construction or beneficial construction, was adopted in interpreting Section 123C of Railways Act 1989, and it defined untoward incident, okay, and it included accidental falling of a passenger from a train carrying passengers. Okay, now accidental falling of whom? One who is already inside or one who is trying to board. Okay, now it's talking about passenger. What kind of interpretation is to be taken? So you see, we have two options. One that says that one who is already on board. The other one, an extended meaning, would include one who's trying to board. So which one is to be preferred is the question. So in this particular case, the question was whether the expression untoward incident so defined will cover the cases of passenger who fell and died while trying to board the train, and his dependents will be entitled to compensation under the said provision of the Act. That's the question to be decided. Okay, so this was not one who was already on board. So the court held, no doubt it is possible that two interpretations can be given to the expression accidental falling of a passenger from a train carrying passengers. The first being that it only applies when the person has actually got inside the train and thereafter falls down from the train, while the second being the wider one, okay, that it includes a situation where a person is trying to board the train and falls down while trying to do so. So this person is not yet on board. So whether such a person will be entitled to. So as you know, it's a beneficial, a statute. So since the provision of compensation in the Railways Act is a beneficial piece of legislation, it was held that it should receive a liberal and wider interpretation and not a narrower or technical one. And hence, in the opinion of the court, the letter of the above mentioned two interpretations, the broader one that will entitle the person to the benefit, is the one which has been accepted. So that is the one which advances the object of the statute and serves its purpose. So that's the kind of interpretation we are referring to. So you see, in this particular statute, clearly the objective was to provide benefit. So the court preferred the interpretation that extends the benefit rather than the one that restricts it. So Justice Krishna Iyer had said that, recall the face of the poorest and the weakest man whom you may have seen and ask yourself if the step you contemplate is going to be of any use to him. So you see that this is much more on the line of that sociological, school-based approach to interpretation. So judges expand the meaning in order to expand the benefit. So it's kind of social justice that the judges do, and it applies clearly when it comes to legislations which are social justice, which have this social justice as one of its purpose, which has welfare benefit as its purpose and object. So that's the kind of legislation if we are referring to. Then we are to adhere to the beneficial or liberal construction. Then the next important case that we can discuss is by the name B. Shah versus Presiding Officer, Labor Court, 1978. So in this particular case, whether we are concerned about whether the maternity computation, whether the computation of the maternity benefits, so maternity benefits computation prescribed under the Maternity Benefits Act 1961 has to be made taking a week as signifying a cycle of 7 days. Okay, that would also include Sunday, or a cycle of 7 days minus the Sunday. So if it is minus, then fewer days will be counted, so less benefit. And if it is included If the Sunday is included, then more days, then more benefits. So these are the two options available, okay? So Sunday is considered as a wageless day, okay? So which one is to be considered? One that extends the benefit or one that reduces the benefit? So that's what, was to be decided. So in this particular case, the court held, as you would expect, that Sundays must also be included in the calculation. So the court applied the beneficial rule of construction in favor of the women worker, and observed that the benefit conferred by the act, read in the light of Article 42 of the Constitution, was intended to enable, so basically directive principles, okay, was intended to enable the woman worker not only to subsist, but also to take up her dissipated energy, nurse her child, preserve her efficiency as a worker, and maintain the level of her previous efficiency and output. So you see that the intention of, as the name itself says, Maternity Benefits Act. So you know that this is and if you look at the object, that will explain it further, that it's clearly a piece of beneficial legislation. So in such case, the interpretation that expands the benefit, okay, is the one which is to be preferred to the one which does not. So it was held that in interpreting the provisions of beneficial pieces of legislation which is intended to achieve the object of doing social justice to women workers employed in the plantations, which squarely fall within the purview of Article 42 of the Constitution, the beneficent rule of construction, which would enable the women worker not only to subsist but also to make up for her dissipated energy, nurse her child, preserve her efficiency as a worker, and maintain the level of her previous efficiency and output, has to be adopted by the court. Okay? Now, I told you earlier that whenever the legislation has enacted to give effect to the directive principles, okay, then liberal or wide interpretation or beneficial construction is done. Now, what does Article 42 deal with? So it says provision for just and human conditions of work and maternity relief. So that was the directive which was given effect to under this particular legislation. So the interpretation that effectuates the same is to be preferred to the one that does not. So that's what beneficial construction is all about. So in such case, instead of restricting the people from getting the benefit of the statute, court tends to include as many classes as it can while remaining faithful to the wordings of the statute. So it says that if multiple meanings are possible, then the one that enlarges, includes, then the one that excludes is the one to be preferred. So as long as the wordings of the statute allows, okay. So if you go by the extended meaning, then you enlarge the benefit. So in that case, that's the one that is to be preferred. So Maxwell had said, courts will not supply omissions, okay, but where they are faced with the choice between a wide meaning which carries out what appears to have been the object of the legislature more fully, and a narrower meaning which carries it out less fully and not at all, they will often choose the former, okay. The beneficial construction, however, is to be understood as a tendency and not as a rule. So it will depend to a lot extent on the ideology, the philosophy that the judge subscribes to. And I gave you the example of Justice Krishna here, and you obviously know why. So that's what this rule is all about. Let's look at some other cases, and that will make it more clear to you. So the next case that we can discuss is by the name Alembic Chemical Works Company Limited versus the Workmen, 1961. So in this particular case, we are concerned about this, okay. So in the facts are like this. So an industrial tribunal had awarded more number of paid leaves to the workers under section 79(1) of Factories Act. Okay, so the Factories Act basically standardizes certain number of leaves that one is entitled to, but the Industrial Tribunal awarded more number than that standardized number of leaves made available. The same was challenged in the court. Okay, however, the court held that it's a beneficial piece of legislation. So we will go with the one that enlarges the benefit, okay, extends the benefit, than the one rather than the one that uh, reduces the benefit. Okay, so it said that it had to be, so in such case the act had to be beneficially construed in favor of the respondents. Okay, if the language was capable of reaching one was not capable of reaching one firm meaning, since in the present case the provision was capable of two interpretations, one which was likely to defeat the policy of the act and the other likely to achieve it by giving benefit to the workmen, the latter construction had to be applied. So it said in this particular case, it is well settled that in construing the provisions of welfare legislation such as the act in question, that is your Factories Act, which has for its object the preservation of health, safety, and welfare of workmen. So clearly it even says welfare. The court should apply the rule of beneficent construction. So that's what the rule is all about. Let's look at one more case, okay, and that goes by the name Unikoi and others versus the state of Kerala, 1962, AIR SC12. Okay, so in this particular case, we are concerned about Minimum Wages Act, okay, 1948, under which the state government is, under this particular act, the state government is empowered to fix minimum wages, okay, and whether that is in violation of Article 19(1)(g) of the Constitution, inasmuch as the act did not define what is minimum wage and made no provision for taking into consideration the capacity of the employer to pay. So obviously, as you will know, it was held that no, there's basically no such conflict. So it held that in view of the decisions of this court, the constitutional validity of the act could no longer be in doubt, and any hardship that may be caused to the employers by the wages fixed under the act or their incapacity to pay the same are irrelevant considerations in fixing the wages. So the one that, the one interpretation that benefits is the one that is to be preferred. So that's what, I think, these make it quite clear what beneficial, constructions are all about. It says that the fact that a section has been clearly designed to afford relief, okay, has the tendency, okay, that may incline the court to construe it more benevolently than it might in a case of less obvious remedial enactment. So you will know whether judges will, take the liberal or the restrictive interpretation. That will clearly depend on what the nature of the statute is. So a few more cases, okay. Now the next case is by the name Covington versus Wright, 1963, Queen's Bench, case. So we are concerned about Section 91(1) of London Transport Act 1936, and it provides that every passenger shall, on request by an officer or servant of the board, either produce and, if so requested, deliver up a ticket or give the officer or servant his name and address. So how is the said provision is to be interpreted? So Lord Parker had said that the servant did not have to, in such case, okay, the officer or the servant did not have to go and put each request separately. Okay, will you deliver up your ticket? Show me your ticket. Will you pay the fare? Will you give your full name and address? So it says it is sufficient if in all the circumstances of the case the conductor or inspector makes known to the passenger known that the passenger must comply with one or the other request. So you see, I mean, which interpretation should we go ahead with? The one that makes it difficult or the one that makes it easy? So the beneficial construction obviously was preferred in this particular case. The next important case that we can discuss, okay, is by the name Attorney General of New Zealand versus Lower Hutt City Corporation, 1964. In this particular case, a particular statute, New Zealand statute, empowered a corporation to construct waterworks for the supply of pure water for the inhabitants of the district. Now that's what it has been authorized, okay? It's for the supply of pure water to the inhabitants of the district. Question is whether it also authorized addition of fluoride. So Lord Upjohn had said that it would be an unnecessarily restrictive construction to hold that because the supply of water was already pure, that there is no power to add its constituents merely to provide medicated pure water. So the one that enlarges, the power and it's for the good, so is the one which is to be preferred. So there could be many other examples that we could take up, but I think this should suffice, okay? This should suffice for you to understand that if the nature of the legislation that you can ascertain from the name, from the long title, from the preamble, if any, from the nature of the, from the purpose of the, provision, ex visceribus actus, that it is a beneficial piece of legislation, welfare legislation, social justice legislation, if that's the, objective, in such case, if the words allow two different meanings, okay, one that restricts, the other one that enlarges the benefit, then the judges, without overstressing the word, overstretching the word, if they're able to go ahead with the one that benefits the subjects, okay, then they will go with the one that benefits the subjects, okay. So if that kind of interpretation is applied, then we call it beneficial or liberal interpretation. Well, that's it. I think that should suffice. And if you guys have any other queries, difficulties, questions, then feel free to write to me. And all the cases will also be shared with you. That's it. Thank you. Good day.